For some of you, can you just go? Yeah, can you just go back for something? I'm very, very pleased to meet you, sir. Thank you so much. You very pleased to meet you. Thank you so much. Hello, Dr. Rao. Thank you very much. Very good. What are you trying to do? I'm going straight to reception. Yeah. That's it. Yes, so much. Yes, so bunch of disease. That's the sea we can finish. Good evening, everybody. I am deeply honored and delighted to welcome you all to this special lecture on current work and developments of UNCITRAL by Dr. Anna Joubin-Bret, Secretary UNCITRAL and Director International Trade Law Division, Office of Legal Affairs, United Nations. I also welcome all other dignitaries on and off the dais, including officers from UNCITRAL Secretariat, our life members, students, and other guests. So before we dive into the lecture, I would request our President, Shri Praveen H. Parekh sir, to present a bouquet as a token of appreciation to our esteemed speaker. I would also request our Secretary General, Sir, Shri Narendra Singh sir, present the committees of the society to Ms. Red. Thank you so much. Now I would request our President, Shri Praveen H. Parekh sir, to give his formal welcome address.
Honorable Madam Anna Joubin, and my dear colleagues and friends and students. Our great question was come here from Anna is the United Nations Commission on International Trade Law is therefore legal body of the United Nations system in the field of international trade law, a legal body with universal membership, specializing in commercial law reform worldwide for over 50 years. UNCITRAL's business is the modernization and harmonization of rules on international business. It is important to briefly introduce about the ISL. Was established in 1959 with the objectives for inter alia disseminate the knowledge of international law and to undertake comparative research of international laws. ISL publishes Indian Journal and International Law since its inception, and which has attained a high standard and is held in high esteem the world over. ISL has a library exclusively on the subject of international law. It runs the postgraduate diploma courses through its academy. Our eminent guest is an expert in the field of international trade law. MS Anna is the Secretary of the United Nations of Commission on International Trade Law, UNCITRAL, and the Director of the International Trade Law Division in the United Nations Office and Legal Affairs, which functions as the substantive Secretariat for UNCITRAL. She is the ninth Secretary of the Commission since it was established by the General Assembly in 1966. Prior to her appointment On 24th November 2077, she practiced law in Paris, specializing in international investment law and investment dispute resolution. She focused on serving as counsel, arbitrator, mediator, and conciliator in the international investment dispute. She served as an arbitrator in several SID, UNCITRAL, and ICC disputes prior to 2011. And earlier, Madam was the senior legal advisor for the United Nations Conference on Trade Development. She edited and authored the seminars, research, and publications on international investment law, notably the sequels to the Institute IIA series and in-edited with Jean Kelky, a book on reform of investors state dispute settlement in 2015. She holds a postgraduate degree in international private international law from the University of Paris and a master's degree in international economic law from the University of Paris and a political science from the Institute of Politics. She was a legal counsel in the legal department of the senior group of the EIS group and director export of Cordially. She was appointed judge at the commercial court in France and was elected regional councillor of Alpes region in 1998. We are very, very happy that she has come to the US. Thank you very much, madam. And we are going to hear to you for a wonderful speech from you. Thank you very much.
Thank you so much, sir, for your address. So today we have the privilege of gaining insights into the remarkable strides UNCITRAL has made. And without wasting much time, I would like to invite ma'am to deliver her talk. You're welcome, ma'am.
Thank you. Thank you very much. I'm extremely honored, first of all, by the flowers. In our tradition, it's only after you have sung very beautifully that you get a bouquet. So you expect me to sing beautifully. I will try. Will try my best. Well, thank you very much for this great honor that you're giving me and my colleagues by receiving us here in this learned and very highly qualified audience at the Indian Society of International Law. It's a great pleasure to be speaking about what we do as part of the United Nations Secretariat and how we contribute to unifying, to modernizing, and to harmonizing international trade law. So I might actually begin, and I thank you, Dr. Parrott, for having introduced UNCITRAL briefly. But I'd like to begin by explaining a little bit of what we do. You are certainly more familiar with the work of another commission of the United Nations General Assembly, which is the International Law Commission. The International Law Commission is focusing on codifying public international law, and we focus on codifying, harmonizing, and modernizing international trade law, so mostly private international law, but also international trade law with a very broad meaning. We do not concentrate on international trade law as you would know it from the World Trade Organization. We're not setting rules on trade flows between countries, but we are working very much at the infrastructure level to facilitate exchanges, transactions, contracts, and dispute resolution among other areas of our work, among traders and including states in several instances among the globe and from one jurisdiction to the other. We work very closely in our work with another organization that you probably know of, which is the Hague Convention on private international law. They are more in the conflict of laws field, and we are more in the facilitation, in the, as I said, infrastructure to enable transactions to flow and to take place between jurisdictions. So our commission is contrary to the International Law Commission, which is where you have a limited membership with people who are elected and then act in their personal capacity. We are an intergovernmental commission in the sense that it's our member and non-member states that participate in UNCITRAL's work. They can do so through experts of their choice, but ultimately the decision-making organ is the Commission, and the Commission is composed of states. So by way of background, we started our existence many years ago, as you recalled, with as sort of a follow-up to the establishment of the New York Convention on the recognition and enforcement of foreign arbitral awards, which was concluded in 1958. And from the decisions from the implementation of the New York Convention, the need arose to establish a commission that would oversee and facilitate the continuous harmonization of different models of legal traditions, different models of trading and resolving disputes among jurisdictions. Our commission counts actually, for the time being, 70 member states. It has been enlarged recently from 60 to 70 member states, but we do not make a difference between member states and non-member states. Everyone is speaking in the same capacity, and Ambassador Gudmundur can vouch for that. Being a non-member state of UNCITRAL, you still sit in our deliberations and contribute very actively to that. So that's basically the way we function. So we have a commission, a session that meets once a year that adopts the work done by UNCITRAL and by UNCITRAL's working groups. And this work takes the form of different types of instruments. We work and prepare international conventions, international treaties. We also prepare and adopt, the Commission adopts model laws, model legislation that has the same effect as the convention, with the more flexible approach to states to enact it into their own legislation. And we have, of course, a whole array of legislative guides, guides for enactment of legislation or conventions, notes that the Secretariat produces, or guidelines for the use of our texts, and of course rules that can be incorporated into contracts that can be used by private parties in order to settle their disputes. So in a nutshell, this is what is being produced by the 6 working groups that are established currently and function currently under UNCITRAL's body. One working group that works particularly or specifically on MSMEs, another one on dispute resolution, a third one on investor-to-state dispute settlement reform, a fourth one on e-commerce, but we are embarking now on a transition into what we call digital trade, which is even more intensively technology dependent, and which involves more and more machines that are more clever than human beings when it comes to entering into contracts or placing orders. And we have a fifth working group that works on insolvency. Currently, it's developing a text on applicable law to insolvency proceedings, and also working on asset tracing and recovery in civil insolvency cases. And the sixth and last working group that the Commission has is currently working on a transport document, documents of title, negotiable documents of title for for a multimodal transport of goods, of cargo. We originally called this project a project on railway consignment notes, but it has expanded towards now multimodal transport, which means that we also include maritime and road transport, and that we will devise an electronic document that will be both a document of title and a document, a negotiable document that enables you to get financed for the goods that you transport. So this is really you can see is a wide array of areas that have very little to do with one another. Some are more on dispute resolution, the well-established UNCITRAL work on arbitration and mediation, and others are much more technical, relating to, for instance, maritime transport or negotiable documents. And I'll talk a little bit more about that at a later stage. But given the, I imagine, prevalent experience and expertise of this distinguished audience in public international law, I thought I would try to focus my talk a bit on the public international law instruments, our conventions, and the questions that arise from some of our ongoing work. So let me begin with, yes, I don't know by what magic are you pushing the buttons here? Oh, thank you so much. Oh, Ambassador, I feel indebted. Thank you. Well, that's because we're supposed to be technologically neutral. We don't push on buttons. So simply to advertise the latest, the newborn UNCITRAL convention, which has been signed last week, which has been open for signature last week in Beijing, which is called the Beijing Convention, and which is focusing on the international effects of judicial sales of ships. So really strictly maritime commerce, maritime trade, also of finance, of course, of maritime trade, insofar as it is meant to give certainty to all the actors, to all the stakeholders in the ownership of ships, particularly when these ships are being sold in judicial sales, with a view to creating certainty in the ownership, in the title over the ship, in establishing a clean title, and ensuring that ships cannot get arrested, which of course creates problems for those who finance the shipment, for those who have given their cargo out to transport, and of course also for the crew members that are stuck on board of a ship during the time of a judicial procedure. So this instrument, as I said, is the latest one that has been negotiated in UNCITRAL. It was adopted by the General Assembly, as all our conventions. Our conventions go to the General Assembly for adoption in order to turn them from an UNCITRAL text into a United Nations text or United Nations convention. Here we had an adoption last year, and we then had subsequently China offered to host the signing ceremony, which was very well attended. And it's a pity that we cannot include the pictures, but it was a grand opening ceremony. And we had already 15 countries signing on to what could be considered as a fairly technical convention. But countries such as, of course, China or Switzerland, which has a very important maritime finance industry, Saudi Arabia, Senegal, Sierra Leone, Liberia. So the list goes on, and at the same time, we're quite confident that very soon this convention will be followed or will be acceded to by the European Union countries that were very keen in the negotiation. Problem is that it takes time for states to um, go through the domestic procedures before they can accede. And what we're hoping very much is that India, being also a very strong maritime country, would also join this convention sooner than later. So we just maybe on this convention, one more word to say that we put it together, we negotiated it in UNCITRAL with the support of the Comité Maritime International. They were very interested in bringing it to UNCITRAL for the negotiation of the convention, and it was agreed that the International Maritime Organization would be playing the role of the registry for the sales of ships, which is, if you think about it, a long overdue function to ensure that the thousands of ships that are being sold are registered somewhere where their clean title can be established. So that is really the latest that I wanted to showcase. And I would like to also very briefly now turn to UNCITRAL's frameworks on arbitration and on mediation. So again, why? Because of two conventions. One that has been the start of the establishment of a complete framework on international arbitration, and one that has arrived as the culmination of efforts of establishing bottom up, if you want, a framework on mediation. So the first framework is the very complete and fairly well-known framework on arbitration, international arbitration, that was established trickling down, if you want, from the New York Convention that established early on in 1958 the the recognition and enforcement of foreign arbitral awards in all countries signatories to this convention. To date, if I'm not mistaken, we have 167 member states, 76.
172 with Timor.
172. Oh, yes, with Timor-Leste being the last one to have joined. So I would say it's quasi-universal. We have a few countries that are still not in the New York Convention framework, but it's probably places where arbitration doesn't have play an important role. So this convention was then, if you want, translated into the domestic framework that is necessary in order to ensure that the domestic courts will indeed play their roles as guardians or as facilitators of arbitration and the enforcement of arbitral awards in various jurisdictions that are members of this convention. And in the case of India, India is not really a modern law country per se, but has its idiosyncrasies that are probably motivated by the sheer size of the subcontinent and the traditions. But we haven't lost hope of counting India as a model law country. We also have, if you look at the way this framework is established, you have the convention at the top to ensure that arbitration can work, whatever the jurisdiction. You have a model law to establish the domestic framework. And then you have a number of notes by the Secretariat, rules that are being developed for parties to use in various contracts that are not necessarily commercial contracts, by the way, because, for example, in the United Nations arbitration cases by the United Nations use the UNCITRAL arbitration rules. We also have recently developed an expedited arbitration rules set to respond to criticism about the time that it takes for an arbitral award to be rendered. Arbitration, you have to remember, is supposed to be a more user-friendly dispute resolution system, particularly in the case of business, as it is supposed to be more to take less time, to be faster, and to also be cheaper. In practice, as we will see, it has evolved into something which sometimes it takes much more time and costs a lot more, but that is another story. So that is for our framework on arbitration. The latest text that was adopted in the Commission session of this year is a text on early dismissal, a guidance note on early dismissal and preliminary determination, that has been adopted by the Commission this year, that will be added to the guidance notes to ensure that tribunals have indeed the power to dismiss at an early stage cases that are otherwise unmeritorious. In so far as mediation is concerned, it's been done the other way around. So we started with mediation rules that, when they were developed, were not called mediation but conciliation. And over time, also a model law on conciliation. And the framework was then developed into a convention that is called the Singapore Convention on the recognition of the effects of mediated settlements. So this Singapore Convention was negotiated as the final, if you want, as the final bouquet on top of an existing framework. This required to adapt the UNCITRAL model law on conciliation in order to make it, to harmonize it with the convention. And the convention itself is, if you want, patterned on the conditions of the New York Convention, in the sense that it sets the rule that any mediated settlement that has taken place in a jurisdiction that is member of the convention will be given effect in another country member, another state member of the convention. There are limited number of conditions for not giving it its legal effects that are modeled more or less on the New York Convention. And you have, of course, as a prominent feature, the fact that it resulted from mediation. So it's not any settlement agreement that you can come up with amongst yourselves, but it really has to be the result of a mediation proceeding. By doing so, many countries found that it was not maybe an indispensable means, as is the case for arbitration, but it has the effect, the additional effect, if you want, to promote mediation as a credible means of settling disputes, which is being used extensively in a number of jurisdictions, but totally ignored in others. So becoming a member of the United Nations Convention on Mediated Settlements has the advantage of really promoting, making mediation, a credible settlement mechanism, which in turn, of course, is important for us in the work that is being carried out currently on investor-state dispute settlement. Now, on arbitration and mediation, what I should also say is that the Singapore Convention is one of our most successful conventions. It opened for signature in 2019. Am I right? Yes, I'm getting a bit confused. It opened for signature, and at that time it had already 46 signatories. So since then it has grown a lot with 56 member states now, and 11 of these countries have ratified. So if you take into account again the time it takes for a state to accede to these, to carry out, and I'm speaking under the authority of the legal advisor of the Ministry of Foreign Affairs, who knows what it takes to accede to any UN convention. And if you take into account the fact that we had 2 years of COVID, it's quite extraordinary to see the appetite for the Singapore Convention. We were just last week in Singapore for what we call the Singapore Convention Week, where we jointly with the government of Singapore do the promotion of the convention, carry out capacity building for government officials wishing to accede and to implement, but also for mediators, for investor-state disputes, and for the industry in order to use the mediation more and more. So if you allow me this sort of adapted structure, I spoke about our convention in the area of judicial sales of ships, maritime law. I spoke about our 2 flagship conventions in the area of dispute resolution. Let me talk now more about the work we are doing in 2 areas that I thought would be of interest to you and raise a number of public international law issues that I would like to put forward to this learned and distinguished assembly. In order to do that, I would like to maybe I can start with that, and then I can go to investor-state dispute resolution. So the first topic I would like to raise in this connection is the work we are starting to do at a very exploratory phase, at an early stage, on the nexus between international trade law and climate change. So you see, and this is unfortunately true in many areas of international law, you have these frameworks developed in silos. So these areas of international law with conventions, with bilateral or multilateral or regional treaties develop, and they ignore most of the time what is happening in another area, especially in the economic field, which doesn't have a lot of contact points with public international law. And this has been the case, for instance, in the area of investor-to-state dispute settlement, where you're probably familiar with the fact that investment protection has developed over the years through mostly bilateral investment treaties concluded between host states and home states of investment, with a view to promoting investment flows and protecting investments established in this country. On the other side of the spectrum, you have all the development, mostly in recent years, of UN instruments, with the first binding ones becoming the Paris Agreement, which includes very strong commitments on the part of states to reduce their carbon footprint, to put it in layperson's terms. And these 2 frameworks have never actually interacted, whereas a number of measures that are taken by the states that have adverse effects over investors are measures that are taken for the protection of the environment, for fostering or for enabling alternative energy sources. And so a number of these measures are focusing on protection of the environment, while at the same time you have states having a framework which is meant to protect investors against any adverse impact of states' legislation. So this is one area of this nexus, of this tension, but there are many others where you don't have tension, but you have complementarity. You have, for example, complementarity between the commitments that the states have made in the Paris Agreement and their contractual and I want to say public procurement legislation, which means that whatever they commit at the international level has to be reflected in their rules and in their procedures for public procurement. Similarly, when the state, having committed to reduce carbon emissions, contracts in a public-private partnership agreement, it will also want to reflect this need to match these overriding, overarching commitments made under the Paris Agreement. So this is something that, in our view, in UNCITRAL, trickles down perfectly into two of our existing model laws, one on public procurement, the other one on public-private partnerships. Similarly, you have, of course, contracts that are being concluded that benefit from the UNCITRAL contractual framework and the default rules that UNCITRAL has developed, and for which it may be important to identify areas of to update and to match the broader climate change commitments that are made. So this is an area which we have just put on the table. The Commission was both quite interested in, for example, identifying what is the legal nature of these new instruments or these new tools that have been developed under the Paris Agreement in order to engage the private sector into decarbonization. And this is, for example, these carbon credits. Now, if I asked anyone here in the room what is the legal nature of a carbon credit, I'm sure that we would hear very different points of view. The fact that nowadays there is a voluntary carbon credit market and a complete compliance carbon credit market without actually knowing very well what we sell and what we buy, what we hold, and what happens if you have a very important bulk of carbon credits and you go bankrupt. What is it? What is this? Is it it's an asset, that's for sure, because it has some value, but it is an asset that is in need of legal definition in order to give it more certainty as a tool identified under the Paris Agreement's Article 6 as a mechanism to engage private investment into decarbonization. So that I wanted to take this example to show you how at the very bottom, at the infrastructure level, UNCITRAL can do something useful for the implementation of a broader, much broader and completely out of our purview instruments such as the Paris Agreement. And the view, our view when putting this on the table, and I must say that India was not very supportive of this of this effort. Putting it on the table for us was really to respond to this I don't know how to say that, to this phrase that the greatest threat to climate, to the planet, is to think that somebody else is going to take care of climate change. And here what we think is that it's something we need to tackle, also because there is an impact in what we do, a possible positive impact in what we do on climate change. Another area that I wanted to touch upon also very briefly because of its public international law impact, and I'm mindful of the time, is the New York Convention. I mentioned earlier, and I'm sure you're familiar with the New York Convention. I mentioned earlier the fact that we have now 100 and again 72 member states, so it sounds totally unrealistic to reopen the New York Convention with a view to modernizing it. But we still have to think about some recent developments, particularly after the pandemic, with the increase in the use of digital tools and digital technologies. Nowadays, it seems really, how can I say, from the Stone Age to still require arbitrators who are sitting in 3 different parts of the world to sign a blank paper, to send it by mail to the arbitration center that will then combine them on the final award so that the award is made in writing. So we will have to do something about that. You cannot promote in all areas of the law the use of electronic signatures and electronic transfer of documents, of evidence, of even serving a notice. And you have to reflect the fact that this is now becoming more and more mainstream in domestic courts, and have arbitration lagging behind and being one of these, old-fashioned methods of settling disputes. You might as well put on a wig and carry a red case. So we are thinking that something will have to be done about the New York Convention, and we will have to think about the best way to carry that out. And now, very briefly, in the 5 minutes that are left to me, if we want to have some discussions, we are also working on the reform of investor-to-state dispute settlement. Ambassador, if you can push my buttons a little bit, and just to give you the mandate that has been entrusted to UNCITRAL's Working Group 3 is to reform investor-to-state dispute settlement. It's a broad mandate in the sense that it doesn't say what needs to be done. It's a broad mandate in the sense that it is not finite, but it is also a mandate that requires that it is carried out by states, that states are the ones making the decisions in the room, that we have around us, with us, knowledgeable experts that represent all the stakeholders, as many as possible. But at the end of the day, this is a system that has been established by states and should be amended by states according to the mandate we have received. So what is put on the table, if we can, so no, more than that actually. That goes very slowly. So you see here that the mandate means that it has to be government-led with high-level input, decision-making capability for those in the room, consensus-based, the way we always work, completely transparent. Everything you want to know about what we're doing is available on our website, including the recordings of the different interventions by states and NGOs and IGOs. And of course, we have expertise that we will receive from various stakeholders. So I'm going to go very quickly on that, and just to give you a flavor of where we are currently. We are at the 3rd stage of our mandate, which is the stage of the implementation of the reform options that have been identified and put on the table during the 2nd phase, after the working group has evaluated the problems arising from investor-state dispute settlement. If you want, in a snapshot, the problems could be bulked together as issues of legitimacy of the system, issues of cost and duration, and issues of consistency, predictability, and certainty of the law on international investment. And in order to remedy these different shortcomings of the investor state dispute settlement system that has been built on international arbitration being the mainstream way of settling the dispute, the states have made a number of proposals that are now at the implementation stage. We started with developing what was easier, the alternative dispute resolution methods with a view to proposing more avenues for settling these disputes and not having only as one way investor state arbitration. We also developed and adopted at the Commission session this year guidelines and additional provisions to be included into investment treaties for the use of mediation as a credible means. That's why I was telling you earlier that there is a link with the work we were doing in Working Group 2 on the mediation framework. Because, of course, with this credible framework, it's easier to advocate for investment mediation as a credible solution. We have developed, and that has not been that easy, a code of conduct for arbitrators in order to avoid all the issues of legitimacy and bias that have been surrounding investor state arbitration. And I'm not going to go into details, but there were quite strong views in the room about how far disclosure and how far impartiality and independence should be taken, bearing in mind that arbitrators were up to last year the only legal profession that had no code of conduct. So, you know, we all have codes of conduct in everything we do, whether judges, whether diplomats, whether UN. But arbitrators, strangely or not, had no rules and no guidance, no ethical guidance. So this is done now, and we developed it jointly with the World Bank ICSIL. We are working on establishing a multilateral advisory center for developing countries with a view to helping them at different stages or in a different range of advisory capacity, from giving them advice on how to select an arbitrator or to hire a lawyer, to the representing the country completely in an investment arbitration. It's very much patterned on the way the advisory center on dispute resolution in the WTO works, except that, of course, in the WTO it is state to state, so it's meant to help states sue each other. Here it's meant to help states defend themselves against investors bringing claims. Last, very important, yes, madam, last important element of reform is the establishment of a court. And this is a proposal made by the European Union to set up a first and a second instance court. There is appetite for setting up a court, but I would say a moderate appetite. States are generally wary of establishing multilateral courts, tribunals that then have a life of their own. But there is much more interest and traction in the second level, which is the establishment of an appellate mechanism. Here again, the example of the WTO came quite handy in spite of its many problems that it currently is currently facing. So all of this will then be included into a broad multilateral convention. So here again, the result will be a multilateral treaty that will enable states in a very flexible manner to opt in different protocols, because not everybody will become a member of the advisory center. Not everybody will be interested in the first instance court. More states will become interested in the appellate. So it's a sort of a la carte menu, if you want, that states will be able to accede to. And of course, in addition, a number of procedural rules that will be changed. I would, if Atita allows me, just like to push the button a little bit more to show you what we consider this could look like, because that's I'm a very visual person, and when I see something, it helps me understand how it could look like. So basically, what you see here are the four avenues that will be available to investors to bring cases against states. In the case of India, the main door will be the exhaustion of local remedies, of domestic remedies. Other countries will want to continue using arbitrations. Others will want to go to the first instance court. And a number of countries are still favoring state-to-state disputes. For example, in the Mercosur country, Brazil is very strongly advocating the use of state-to-state. What is going to radically change the picture is the setting up of a second floor, the second floor being an appeal facility that will work both as an appeal of arbitral awards and an appeal of the first instance court judgments. You can imagine the difficulties of changing the ICSID convention, which has about 150 something members, which provides that an ICSID award is final and binding and not subject to recourse. But we will change that. The states will do that. And you will see also on the both sides the two additional elements of reform. One, supporting the parties, particularly the state parties involved in investment disputes, and on the other hand, broadening the or favoring recourse to ADR and to mediation. When is this going to happen? My colleague Jason Lee here, who is the main architect of this reform, has promised to deliver all of this in 2027. And we are all looking forward to all big reform elements by that time. Thank you very much.
If anyone of you want to ask some questions to Menon, please do. Yes, please.
Thank you for the lecture. It was really enlightening. And to bring to your notice, I have just written a piece on the code of conduct of arbitration. But it was, of course, published on the Indian website Bar and Bench, because I tried for the newer arbitration, but somebody already had written for that. So somehow it was not published on newer arbitration, so I tried my best. So my question is, of course, it is a very unique kind of code, because till now there is no code for any arbitrator. And I have worked for ISDS cases from the government side. Right now, I'm not working with the government. My only question is that what with the implementation or enforcement of the code of conduct? Because it is not in the form of convention or a treaty. So it is, in my opinion, more of a soft law kind of thing. So that is my question.
That is an excellent question. Thank you very much, because this is really important. For the time being, the code has been adopted, but it's hanging there. It's hanging there, and it is not related to any particular instrument that would make it enforceable. So, first avenue to make it enforceable is, of course, to attach it or to reference it in investment treaties. The second one is going to be the way our colleagues from ICSID are going to attach this to the request and to the commitment by arbitrators that they signed and they accept to be appointed. The third one that we are not yet envisaging, because we are very reluctant to change the UNCITRAL rules all the time, is probably to have a special set attached to the UNCITRAL rules in the case of investor-state disputes. The code itself envisages that it can be used by anyone who wants to use it. You know that very well. And ultimately, it will become part of the multilateral convention that my colleague is going to put on the table in 2026 for adoption in 2027. So by that time, it will become hard law as opposed to being soft law, which it is for the time being. Yes, very true. Thank you. Excuse me for putting you on the spot. Yes, please, sir.
I teach at Indian Society of International Law. My name is Menon. Uh, Primarily and sensitive UNCITRAL is being for being a qualifying the private interest. And over the years, last 1 decade, there are some certain subject matter of public equality flowing also. That how that mandate shifting from the private law to public law going to be taken care by the UNCITRAL, keeping in view that investor state dispute settlement mechanism work largely has been grown up and developed under UNCTAD. So under the UNCTAD, United Nations Conference Trade and Development.
Yeah.
Largely it has been work has been done in UNCTAD. So that there could be what can say the jurisprudential challenge will be there on that aspect to the first, and the mandate for UNCITRAL is being seen is wanted historically to develop related to private interest law, and then going to take challenge about the private public interest law. How the jurisprudence could be currently involved.
Well, thank you very much. As the former legal advisor to UNCTAD, I'm very glad to tell you that UNCTAD has never been a negotiating forum for international rules in the area of investment. The UNCTAD has negotiated in the area of restricted business practices. There is an UNCTAD text, but on anything else, UNCTAD has always been more from more a think tank for developing countries, a research body, an economic resource for developing countries, and not a place to negotiate and to develop any law. So UNCTAD doesn't have this role and this mandate to develop law. We have it because we are a body of the United Nations that develops law. Now, we develop mostly private international law, but we do it through public international law instruments, and we have a number of our texts that are, I would say, that target beyond only the relationship between traders. Okay, so for example, the insolvency framework is all about the state adopting an UNCITRAL framework, which is not something that is being used between traders. So from that point of view, we are quite we are a place where these kind of rules can be negotiated because it's our role to negotiate text, and investor to state dispute settlement is sort of a hybrid, if you want, because you have the private party and the state party, and the state parties are the ones who are negotiating it in UNCITRAL. So I don't feel particularly challenged for that. And another thing that I should add that my colleagues should have reminded me, or would have reminded me, that I would be remiss if I told you that we are not touching substance. We're not touching substantive standards of protection. So we're not going to look into most favored nation treatment or fair and equitable treatment or expropriation. We're looking only at the dispute resolution part of it. If that answers your question, sir.
No, I think we don't have any more time. As another engagement,
Yes, that's why I look
and
like
she's
that.
already getting late for that. You can see her colleagues reminding her. So I thank Dr. Anna Joubin-Bret for coming to the Indian Society of International Law, and coming here at very short notice, in spite of the very tight schedule she has in Delhi. And I thank her for briefing us on the work of UNCITRAL right from the early stages of its establishment to the current work which is being undertaken, and also giving us some idea of the timetable as for the future. I thank her very much for that. I think you could say that she's deserved the pay.
Thank you.
You got it. We thank all the participants, I thank the members of our team, I thank the president and the members of the society and everyone who is here for the interest you have taken in the subject and for encouraging us in our activities. Thank you.
Thank you. Thank you. I see that really have to escape because
So see you all later.
we might have a very big and that's not going to be
Give us
very easy.
one photo.
So thank you.
Thank you. So that was short. So you can do it, then you don't. Thank you.
Participants, Kitty will also serve.
Oh, good. Oh, that's great. That's great. Yes, 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 yes. Let's have a photo. Yes. So I will tell my take my friend. So I sound well.
Thank you.
Thank you so much. Thank you. Thank you. Please, come out. What reason?